Good day, everyone. My name is Juanito Cabo III. I am the last reporter of the topic extract from the new Civil Code, Article 281 to 289. Article 281, Realization of Pledge of Properties. Pledge of property against which execution is live in accordance with Article 280 of the present code shall be realized, sold by means of sale at public sale in the procedure established by the legislation. At the request of the pledger, the court shall have the right in deciding the levy execution against pledged properties to defer to sale thereof at a public sale for a period of up to 1 year. The deferral shall not affect the rights and duties of the parties with regards to an obligation secured by the pledge of this property, and shall not relieve the debtor from compensating the losses of the creditor and penalty which grew during the period of deferral. The initial sale price of pledged property at which the public sale begins shall be determined by the decision of a court in the instance of levying executions against property in judicial proceeding or by agreement of the pledge holders with the pledger in other instance. The pledged property shall be sold at the person who offered the highest price at the public sale. When a public sale is declared to be unconstituted, a pledge holder shall have the right by agreement with the pledgers to acquire the pledged property and to set off against the purchase price his demand secured by the pledge. The rules concerning the contract of purchase sale shall apply to such an agreement. In the event of a second public sale is declared to the unconstituted, the pledge holder shall have the right to retain and subjects of pledge, valuing it in an amount of not more than 10% less than the initial sale price at the second public sale. If the pledge holder does not take advantage of the right to keep the subject of pledge within a month from the date of announce of the second public sale being constituted, the contract on pledge shall terminate. If the amount received when realizing the pledged property is insufficient to cover the demand of the pledge holder, he shall have the right, in the absence of another indication in a law or the contract, to receive the amount in arrears from other properties of the debtor which does not enjoy the preference based on the right of pledge. If the amount received in the event of the realization of the pledge property exceeds the amount of the demand of the pledge holder secured by the pledge, the difference shall be returned to the pledger. A debtor or pledger who are a third person shall have the right at an time until the sale of the subject of pledge to terminate the levy of execution on it and the realization thereof, having performed the obligation secured by the pledge or that part thereof whose performance has been delayed. An agreement limiting this right shall be null. Article 282. Performance of obligation before time secured by pledge and levy of executions against pledged property. A pledge holder shall have the right to demand the performance before time of an obligation secured by pledge in instance of the subject of pledge departed from the possessions of the pledgers with whom it was left in violation of the condition of the contract on pledge. A violation by the pledger of the rules concerning substitution of the subject of pledge, Article 276 of the present code, loss of the subject of pledge under circumstances for which the pledge holder is not liable if the pledger has not taken advantage of the right provided for by Article 276, Paragraph 2 of the present code. The pledge holder shall have the right to demand the performance before time of the obligation secured by the pledge, and if this demand is not satisfied, to levy executions against the subject of the pledge in instances of violation by the pledgers of rule concerning subsequent pledge, Article 273 of the present code. Number 2, the failure of the pledger to fulfill the duties relating to the maintenance and preservation of pledge properties provided by the Article 274, Paragraph 1, Subpoint 1 and 2, and the Paragraph 2 of the present code. Number 3, the violation by the pledgers of the rules concerning the dispositions of pledge properties, Articles 277, Paragraph 2 and 3 of the present code. Article 283, termination of pledge. A pledge shall terminate, number 1, with the termination of the obligation secured by the pledge. Number 2, upon the demand of the pledger when there exists the ground provided by Article 274, Paragraph 3 of the present code. Number 3, in the event of perishing of the pledged things or termination of the pledge right unless the pledger has taken advantage of the right provided for by Article 276, Paragraph 2 of the present code. In the event of the sale of pledged property at public sale and also when the realization thereof has provided to be imposed, Article 281, Paragraph 5, 6, and 7 of the present code. A national in the notation in the register in which the contract on mortgage was registered must be made concerning the termination of the mortgage. In the event of the termination of pledge as a consequence of the performance of obligation secured by the pledge or at the demand of the pledger, Article 274, Paragraph 3 of the present code, the pledgers with whom to pledge property is situated shall be obliged immediately to return to the pledger. So, Article 284, preservation of pledge in event of transfer of right and pledge properties to another person. In the event of the transfer of the right ownership of pledge property or the right of economic jurisdiction from the pledger to another person as a result of the alienation of these properties with or without compensation or by way of universal legal succession, the right of pledge shall retain force. The legal successors of the pledger shall take the place of the pledgers and shall bear all the duties of the pledgers unless established otherwise by an agreement with the pledge holder. If the property of the pledger which is the subject of the pledge has passed by way of legal succession to several persons, each of the legal successors or acquirers of the property shall bear the consequences arising from the pledge for the failure to perform the obligation secured by the pledge commensurate with a part of the said property which has passed to him. If the subject of the pledge is indivisible or on other ground remains in the common ownership of the legal successors, they shall become joint and several pledgers. Article 285, consequences of compulsory withdrawal of pledge property. The right of ownership of a pledgers to the property which is the subject of pledge terminates on the ground and in the procedure established by a law as a consequence of the withdrawal or purchase for state needs, requisition, or nationalization. Other properties or respective compensation shall be granted to the pledger. In this event, the rights of pledge shall extend to the property granted instead of respectively. The pledge holder shall acquire the right of preferential satisfaction in this demand from the amount of compensation due to the pledger. In the instance when property which is the subject of pledge is withdrawn from the pledger in the procedure established by a law on the ground that is reality the owner of this property is another person, Article 228 of the present code, or in the form of sanction for the commission of a crime or another violation of laws, Article 204 of the present code. The pledge with respect to this property shall terminate. In the instance provided for by paragraphs 1 and 2 of the present article, the pledge holder shall have the right to demand performance before time of the obligation secured by the pledge. Article 286. Assignment of rights regarding contracts on pledge. A pledge holder shall have the right to transfer his right under a contract concerning the pledge to another person while complying with the rules on the transfer of the rights of the creditor by means of the assignment and demand. Article 313-321 of the present code. The assignment by the pledge holder of these rights under the contract of pledge to another person shall be valid if the right of demand against the debtor regarding the principal obligation secured by pledge have been assigned to the same person. Insofar as not provided otherwise, the assignment of rights under a contract on mortgage shall also mean the assignment of rights relating to the obligation secured by the mortgage. Article 287. Transfer of debt regarding obligation secured by pledge. With the transfer of debt regarding an obligation secured by a pledge to another person, the pledge shall terminate unless the pledger has given consent to the creditor to be liable for the new debtor. Article 322 of the present code. Article 288, Pledge of Goods in Turnovers. A pledge of goods while leaving them with pleasure and granting to the pledger the right to change the composition and natural form of the pledged property goods, reserves, raw materials, semi-fabricates, finished products, and the like, on condition that other total value does not become less than that specified in the contract on pledge, shall be deemed to be a pledge of goods in turnovers. A reduction of the value of the pledged goods in turnover shall be permitted commensurately with the performed part of the obligation secured by pledge unless provided otherwise by the contract. Goods in turnovers alienated by a pledger shall cease to be the subject of pledge from the moment of their transfer into ownership, economic jurisdiction, or operative management of the acquirer, and goods of acquired by the pledger which are specified in the contract on the pledge shall become the subject of pledge from the moment the right of the pledger arise to the ownership therein. In the event of violation by the pledger of the condition of a pledge of goods in turnover, the pledge holder shall have the right by placing his mark and seal on the pledged goods to suspend operation with them until the violation is eliminated. Article 289, Pledge of Things in Pawn Shop. The acceptance from citizen on pledge of movable properties intended for personal consumption to secure short-term credits may be effectuated as entrepreneurial activity by specialized organization pawn shop having a license for this. A contract on the pledge of things in a pawn shop shall be formalized by the assurance of the pledge ticket by the pawn shop. The pledged things shall be transferred to the pawn shop. The pawn shop shall be obliged to ensure to the benefits of the pledger at his expenses things accept on pledge for the full amount of their value established in accordance with prices for things of this type and quality of the moment of their acceptance on pledge. The pawn shop shall not have the right to use the dispose of pledged things. The pawn shop shall bear responsibility to lose of and damage to pledged things unless it's provide that the loss or damage occurred as a consequences of insuperable force. In the event of the failure to return to the amount of the credit within established period secured by the pledge of things to the pawn shop shall have the right on the basis of an endorsement of execution of a notary upon the expiry of a grace month's period to sell this property in the procedure established for the realization of pledged properties. Article 281, paragraph 3, 4, 5, 6, 7, 9, and 10 of the present code. After these demands of the pawn shop against the pledger is paid even if the amount received when realizing the pledged property is insufficient for the full satisfaction thereof. The rules for the granting credits to citizen by pawn shop under pledge of things belonging to the citizen shall be established by legislation. The condition of contracts on pledge of things in a pawn shop limiting to the right of the pledgers in comparison with the right granted him by the present code and by the other laws shall be null. That's all my report. Thank you.